My name is Ryan Harris. I'm a partner with Corporate Immigration Partners. Thank you all for joining us today for our panel on election reactions. We work with Envoy Global, who, along with the experienced attorneys of Corporate Immigration Partners, delivers the complete range of services organizations need to attract, hire, manage, and retain a robust global workforce. Combining more than 20 years of immigration experience with an intuitive, best-in-class immigration management platform, we provide the strategic advice and support you need to keep your immigration program ahead. I'm joined today by three of my partners at the CIP firm who bring decades of combined experience practicing in the most cutting-edge areas of U.S. business immigration law. Those partners are Mike Hammond, Jacqueline Pettit, and Ann Walsh. So thank you all for being here with us as well. We are here today because the election has been decided and we are set for another 4 years under a Trump administration. Much of the focus of our national immigration debate has centered on the border and promises of mass deportations. But as for business immigration, there have really not been much in the way of concrete policy proposals announced at this early stage in the transition to a Trump White House. But from our experience practicing under the prior Trump administration, along with assurances of a more restrictionist immigration system that President-elect Trump promoted on the campaign trail, we want to begin today to, number one, set expectations for what changes are likely to come following Inauguration Day in January, and number two, discuss actions employers can take to mitigate any impact on your program. We can look at potential actions from the new administration in three tiers. First, we have the executive actions that a president is empowered to make upon taking office, such as day one executive orders and travel bans. Second, we will discuss potential changes to key regulations that are likely to affect visa eligibility, but are certain to take at least several months to be implemented by the agencies due to the slower formal rulemaking process. And finally, third, we will briefly touch upon some of the more fundamental changes to our immigration system that could only be enacted by a Congress, which now appears likely to be under unified control of the Republican Party. So to kick this off, Ann, I'll start with you. What can we expect to see on day one in terms of executive orders once the new president has been sworn in, and how can employers prepare for these?
Thanks, Ryan. Hi, everyone. Thank you for joining. I thought to kick us off, we could set the stage, get back to some basics, because we're going to be talking about complex concepts. So, Ryan, does the phrase, "I'm just a bill," mean anything to you?
Schoolhouse Rock.
Schoolhouse Rock. So let's kick it off with some Schoolhouse Rock review. If you're unfamiliar, hop over to YouTube later. It's a fantastic short video that many of us watched in elementary school. So to start with the branches of government, we have the executive, the legislative, and the judicial. The executive is the president and federal agencies. They are responsible for executing or enforcing the laws. The legislative, which is Congress, the House and the Senate, they make the laws. And the judicial, the Supreme Court and the lower federal courts. They interpret the laws and determine if they are constitutional. So what can each of these branches do? The executive branch issues executive orders and presidential proclamations. These are directives by the president to use their discretion to determine how to execute or enforce a law. Also, under the executive branch, we're going to talk about regulations, which are rules issued by federal agencies to clarify how a law will be implemented. So regulations or rules supplement laws. They're subject to notice and public comment and publication. And then we have the legislative branch, so Congress, the House and the Senate. They pass the laws being a requirement to do something or a prohibition to not do something. So to pass a law, you need the simple majority in the House, 218, simple majority in the Senate, 51, and signature by the president. That said, you may have heard in the news some discussion about the Senate filibuster, which is relevant to passing a law in Congress. In order to vote on a bill, debate has to close. And the filibuster is a tactic to keep debate open, in theory, for a long time. And in the Senate, you need a supermajority, 60 votes to end debate. So we may see in the second Trump administration, the Senate filibuster used as a tactic to delay or prevent some bills pushed forward by the Republican members of Congress. And then lastly, the judicial branch. They issue decisions, and the highest court to issue the decision prevails. So I hope that's helpful. Again, simply to set the stage, there's a number of different agencies involved, and we're going to talk about what role they all might play in the second Trump administration. So Ryan, to get back to your original question, what executive orders may Trump issue? So what directives may he issue? In the last administration, there were hundreds of executive actions on immigration. So some very specific and technical, and others much more broad and up to interpretation for the federal agencies to issue regulations and policies to implement. So it's been in the news. One executive order that we're likely to see is to end birthright citizenship and require at least one parent to be a U.S. citizen or lawful permanent resident for the child born in the U.S. to gain U.S. citizenship. That said, we're very likely to see challenge on that. The 14th Amendment to the U.S. Constitution says all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States. And my understanding is Trump's plan to end birthright citizenship falls on the phrase "and subject to the jurisdiction thereof." So we're likely to see that attempt and then pretty immediately that challenge. We're also likely to see travel bans, which we saw in the first Trump administration. These are also sometimes known as Muslim bans because they impacted persons from predominantly Muslim countries. We saw a number of versions of the travel bans. I believe ultimately it got up to impacting about 13 countries. For example, Iran, Libya, North Korea, Syria, and Yemen. So we may see that reinvoked based on national security grounds. We may see President Trump issue an executive order revoking processing time goals for visa issuance at the consulates and the embassies abroad. And we might see them, President Trump issue executive orders on increased vetting for visa applicants. Likely to see limits on asylees and refugees, people fleeing dangerous situations, and similarly, rescissions on TPS from certain countries, that's temporary protected status, essentially people who are in the US and can't return home due to dangerous or extremely unstable country conditions. See some revocation of humanitarian parole in different forms, and likely to see the attempt to revoke DACA, Deferred Action for Childhood Arrivals, which was introduced by President Obama. Then lastly, at least for today, we're likely to see something similar to the executive order of Buy American, Hire American, which we saw in the first administration. That order prioritized U.S. workers, and it sought to hold companies accountable for replacing U.S. workers with cheap foreign labor. So from Buy American, Hire American, which we commonly abbreviated as BAHA, we saw lots of USCIS policy memos that impacted petition adjudication and our day-to-day work. And we are expecting to see something similar to buy American, hire American again. So that's what we expect to see, or a small part of what we expect to see. Again, there'll likely be hundreds, some much more impactful and broader reaching than others.
Thank you for that rundown, Anne, and for the basic fundamentals, which are important for us all to understand, which each part of our government is doing to contribute to the evolution of immigration that we're going to see over the next few years. A follow-up question on the Buy American, Hire American order, along with these travel issues related to travel bans and the length of time that it takes for visa stamping. Sounds like the common thread there is that employers should be prepared for things to take longer, whether it's getting your employee back in the U.S. from travel home, or to get a transfer petition for a new hire and extension petition approved, that we should buckle up for that to take longer than it has been. What are some steps employers can take to be ready for those kinds of delays?
Yeah, absolutely. I can jump in and then others can as well. So file for extensions or benefits as early as possible. If you before had policies of only starting at a certain mark in the expiration, start earlier. And then with regard to individuals outside of the US and traveling, make a plan that is going to take longer than we've become used to in the past few years. So in addition to that, do you allow work from their country of citizenship or their country of residence? What sort of complexities are involved in allowing an individual to work for an extended period of time outside of the US? Are there tax obligations? Practically speaking, from your business, are they able to fulfill their job duties from outside of the US? So those are things that certainly employers need to be prepared for.
Thanks for that, Anne. Jackie, turning to you, sounds like the administration has got a lot of flexibility here to issue really a flurry of policy memos, executive orders, actions that can have real impact on immigration cases. What can we expect from the courts? In the prior Trump administration, there seemed to be a mixed record of wins and losses. How do you think it will play out this time around?
Right. So, the president can issue executive orders. Any of those executive orders are subject to judicial review to determine whether they are constitutional. We expect more challenges in the courts as he issues executive orders, as we did last time. In the first term, he did get his travel ban, the Muslim travel ban, through the Supreme Court. However, he was unsuccessful in his Department of Labor rules for increasing wages and elimination of DACA, and some other orders that he put out there. So we would expect more of the same, and also litigation on matters that would impact U.S. companies who hire foreign national workers and rely on high-skilled foreign national talents.
Will be something to watch for sure. Mike, at the USCIS level, let's bring you in here. What does past experience tell us to expect in terms of agency processing times and the way decisions come down on cases like your workaday H-1B transfers and extensions of status?
Yeah, thanks, Ryan. I want to start by saying that during the first Trump administration, when that started, I had a complete full head of hair, and then that happened. So that'll give you some perspective. And obviously, a lot of these things we're speculating, but because of what we've already gone through, we have some pretty good ideas as to what's going to happen. Some of the things that we're fairly comfortable is going to happen is the elimination of what's called the deference memo. The deference memo has been around for 30 plus years, and it basically says that if a case has already been adjudicated once, and say you're in an extension for the same worker, same job, same everything, that the USCIS is simply going to look at what was done previously and give deference to that decision. So you get some certainty involved in things like extensions. And that memo during the first administration was eliminated, which meant that you could have someone who was literally working here for your company for multiple years in the exact same job, who now faces the uncertainty of maybe I'm getting my extension approved, maybe I'm not. And it brings up two practical things. One, as Ann mentioned earlier, to start early. But number two, there's going to be a significant push to try to premium process those cases from the employee to eliminate the uncertainty and the unknown. We're expecting a lot of practical, what we might refer to as minor changes, but would have significant impact. Some that we've talked about or things that the Biden administration did that the new administration might simply go in and remove. For example, H4s now, if they're filed with an H1 and the H1's filed as premium, as a matter of policy, they'll do the H4 as premium as well. That may simply go away and split those out. The automatic extension of certain classes of EAD cards may go away. I-45 interview waivers. For many years, there were no interviews required for I-45 through business employment-based cases. Those were waivers were removed during the Trump administration, put back in as a result of COVID, left out as a result of Biden coming in, and now those could resort back. Certain other things like L2s getting EAD card or being eligible to work without having to get an EAD card simply because of the status of being an L2 may be something else that's removed. I think there's two big themes to all of the policy changes we're going to expect. One is there's going to be less eligible workers in the marketplace, whether that's the removals of DACA, TPS, certain parole programs, asylum, et cetera, but less workers are going to be there available for you to tap as employers. And number two, there's going to be a more difficult process. Some of us believe the more difficult process is put in to simply discourage the hiring of international workers, and maybe that's the case. You can make your own conclusions. Likely going to be slower, likely going to be costlier, likely going to have your involvement more as the HR, as a recruiter, as the individual to be involved in the process. And one of the things that I think businesses dislike the most is it's going to be less predictable. We all like predictability. We like to be able to look at a case and let you know, hey, this is a good case, it's going to get approved. And if we're unable to do that going forward, I think that's going to be a problem. One last thing that I think I want to mention relative to programs, we talk about things that might go away that we're used to. There's also the expectation that certain new programs that potentially could have been positive programs may be brought to a halt. One of the ones that I was thinking of is we had a pilot program for stateside visa stamping. So the idea you've got, say, an H1 worker who already has an H1, they're working for you, that visa stamp expires, and historically they've had to, since 9/11, they've had to go home to get a visa stamp, requiring significant cost, potential of delays in coming back, et cetera. And this last year, there was a program ran to do it through Washington, D.C., stateside, that by all accounts from the Department of State was a successful program, saved a lot of Department of State resources, saved a lot of time for employees, but it's never been actually implemented. That's the kind of program that we think may go away.
And Mike, just a follow-up question here for those in the audience who may be worried about a denial, or if we have less prior deference, if we have less predictable adjudications, is a denial on an individual extension case the end of the story for someone's visa, or do we have tools we can resort to in that circumstance?
It's not the end of the story. I believe that if you file an extension early enough time, you may have the opportunity to refile another extension. You still have time left. And again, that goes back to the point of extra cost. You can attempt to curb what they addressed in the prior denial, whether you think it's legitimate or not. It's pretty irrelevant. And frankly, as history would tell us, sometimes just getting a different adjudicator is all the key. And your petition can look exactly like it did the first time, except a different date, and it will get approved, which can be frustrating. Again, goes back to the less predictability.
Thanks for that, Mike. Jackie, turning back to you, stepping away from the idea of these sort of day one executive actions and the more slower methodical rulemaking that happens in the agencies, what major rules were pursued during Trump's last term that we might expect to be revived in 2025?
So there were a few, regulations and the published rules that came up mostly at the very end of his term that had an impact on employment-based immigration. One was a very robust public charge rule that applied to both non-immigrants and immigrants. That was published. I almost had blocked this out of my memory. The very lengthy forms that were published for an I-129, if you're applying for an H-1B, where you had the foreign national then had to prove that they were not going to become a public charge and had enough money or assets in order to not ever have to rely on public benefits. So that was one that was implemented and then quickly reversed by the new administration.
Something to prepare for when that rule was in place was employees had to produce a lot more personal financial documentation.
They did in an employment-based petition. They had to produce, potentially evidence of assets, but they at least had to disclose any assets, income, liabilities within their household, which they may not want to disclose to their employers. So that was a major one. Toward the end of the term, we also saw the Department of Labor wage rule that was quickly published and greatly increased the prevailing wages that employers would have been required to pay to H-1B workers or individuals going through the PERM green card process. Some of those wages that were published were 40 to 100% higher than wages that data supported were paid to U.S. workers. So that rule was definitely made based on the Buy American, Hire American policies, trying to price employers out of being able to hire foreign talent and so that they would hire more U.S. workers. And we all know that's not really how things work. But that one again was challenged and then ultimately thrown out by the new administration. And also an H-1,
go ahead. Practical question there. If an employer appears stuck with a wage that is just not reasonable, based on sort of market realities, that they're being told through a new regulation that they need to pay based on government data, is there any workaround for that?
Yes. So when that rule was published, we were relying very heavily on private wage surveys to get around the Department of Labor wages, which again is an additional cost to either have access to those surveys or use a service to obtain, to do the analysis of the survey to make sure that we can support the private wage survey being used for the position that the foreign workers being sponsored for. But there are workarounds to that. But again, they could be extra cost, it takes extra time in preparation of a petition. And also sometimes those private wage surveys, the results could be challenged later, either through the Department of Labor or US using those wages in the USCIS filing. So there are workarounds, but they're not ideal, right? Then another late in his term regulation that he tried to pass was an H-1B modernization rule, which was going to be very restrictive. It had a more limited definition of what positions could qualify as a specialty occupation. It tried to limit the definition of an employer-employee relationship and shift burdens onto end clients to when a company would place a foreign worker at a third-party location. And also, hiking up those wage requirements But again, he tried to publish that very late. It was first struck down because it violated the Administrative Procedures Act. He tried to publish again, taking out some of the more limiting criteria, but he did not have time to get that passed. So ultimately it was not passed in his last administration.
So something we could perhaps see revived in slightly
Yes.
altered form to get around those court rulings.
Correct.
Mike, turning to you, what's on your watch list for regulatory changes under the new administration?
Yeah, I think for my clients, which are mainly in the healthcare and the IT space, particularly IT staffing, the wage publication and rule was not horribly significant because of the fact that we're mainly operating in large cities that already possess wage surveys, that it's an initial upfront cost, but once you have that, it was really not significant. The H-1B rule, however, though, was would have been hugely significant. It would have essentially eliminated healthcare staffing. So if you're running a PT staffing organization or a OT staffing, or that it would eliminate that because you would not have been able to comply with the supervisory standards. I believe that most end clients would have rejected the requirements that they would have had to have done in order to accept an H-1B worker. For large staffing companies, I think there's probably some workarounds, particularly the work from home that we now have that's very prevalent, as you can see from this screen. Lots of us working from home. Well, not us, but lots of people working from home. And so I think there's some workarounds that are available in 2025 that were maybe not available in 2019 and 20 that would help. But it's certainly going to be a major change in business. And I think one of the things that we have to really be aware of is we're going to have to, if we're say a staffing company, and we're going to have to work with our clients, our customers, to say, hey, here are the new rules. Here's what we need to do. You still want talent. This is talent you've been unable to find without going through a company like us. Here's what we're going to have to do together in order to actually make that work. So I think there's some opportunities out there, but definitely some challenges. Some occupations are going to go away from being H1 caliber. Occupations like RNs would go away. Occupations, possibly systems analyst goes away. QA goes away. Some of the programmers go away because one of the things that did was they eliminated the employer standard or the employer criteria. For me as an employer, I require a BSN for this particular job, and they made it a national standard only. And so for all those occupations where some companies require a bachelor's for this job, some don't, they're going to look at the Department of Labor standard. And for some of those occupations, the Department of Labor standard is not going to be high enough. So pretty major changes for the H-1Bs, assuming it looks like what it looked like was published before.
That sounds like a good time to be working with your immigration counsel to make sure you've got the right categorization of the roles that you're hiring for. And I wanted to throw this to you now and ask a little bit, again, sort of getting back to the practical with some of these regulatory changes with the Baja order, with the H-1B modernization rule. I think what we saw in the last administration was a real spike in the incidence of requests for evidence. And for folks who might know what that means, when you file a petition, what you hope to get is a quick approval back. You essentially never get a straight up denial, but what you will get in advance of a denial or a potential win is a request for evidence that says, we don't think you proved enough on your case. We need more documentation. We need more information. What does that look like for a program and the burden on an employer if the RFE rate triples, quadruples, or more?
The heightened RFE rate is more expensive and it results in lengthier processing time. It's also often more demanding on HR and beneficiary time in needing to produce documentation for us, such as records of persons similarly employed, showing that they also have a bachelor's degree or potentially prior advertisements that employers have published reflecting that they require a certain bachelor's degree. Then from the beneficiary, the foreign national employee, we may request sample work product evidence demonstrating the complexity and the sophistication of the role. Sometimes we recommend pursuing expert opinion evaluations, and those two increase the cost. So certainly increased requests for evidence increase the cost and processing time and the burden often on both the HR, the immigration coordinator, and the foreign national beneficiary in order to formulate the strongest response.
And again, now being the time to, I think, be working with your vendor, your immigration counsel, to see what kind of supplemental documentation you can do to try to minimize the incidence of these, but you can bet they're going to go up.
Yeah, absolutely. And our firm is sizable and we're able to observe requests for evidence trends coming in. So it's also very critical on our side to be information sharing as to what we're observing, to strategize and front load against common requests. If you've never seen a request for evidence notice before, they can be incredibly lengthy and boilerplate. There can be very little language in the request for evidence that's actually tailored to the specific petition. And so we work closely together to ensure that we're strategizing to the optimal petition for our clients.
Mike, we're talking a lot about direct impact on employees who might be sponsored on a visa. But as we know, employees come with families, and a lot of sponsored workers have spouses working on EADs. Could you talk to us a little bit about what it would look like if the new Trump administration revives efforts that were started in the first go round to remove the H-4 EAD as a benefit?
Yeah, it was certainly something that was on the, let's call it their wish list that they had published of things that they were going to eliminate was dependent EADs. A lot of individuals that come to the U.S. Want their spouses to work, whether it's H's, L's, E's, just a variety of individuals. And that's very common throughout the world for dependents to be able to work. And so there's a likelihood, maybe likelihood, at least a possibility that the EAD program would be eliminated. One of the questions is, well, I have one right now. It's good till 2026. Will it go away? And the answer is, well, we don't know for sure, of course, but historically, they have not eliminated cards that were already in existence. They've simply made it prospective. And so if you are someone who is debating renewing your card right now and you're eligible, you may want to certainly consider renewing before January.
On that same topic of EADs, just briefly, because I know you mentioned a potential change that could come through in one of these day one actions or administrative or executive actions, rather, is to change the circumstance where now an L2 spouse, if you have an L1 worker and their spouse is an dependent L2, right now they don't need an EAD, but that's something that could probably pretty quickly change. And what not everybody might appreciate right now is even though you might not have the EAD and don't need it right now, you have always been able to apply for that EAD. So if you have a spouse working in an L2 EAD, it might be time to just file that application to get an EAD card in the pipeline in case the new administration determines that's required for L2s to work. Jackie, is there anything else that you've got in mind that we haven't covered in terms of preparedness that employers can undertake right now to withstand some of these regulatory changes, to withstand some of these delays?
We've covered most of it, but it is beneficial to just kind of look at your entire immigration population, any non-citizen employees, or anyone who's not a lawful permanent resident or citizen, to just get a good handle on what status they're in, and plan ahead for applying for extensions when they're eligible as early as possible, as Anne mentioned earlier, making managers and other stakeholders aware that you might need to start requesting additional evidence to support petitions, especially for H-1Bs up front. We'll be monitoring the any memos that are released, any RFE trends that come in, but your immigration attorney may want to start front loading certain documentation that we wouldn't normally require in a petition or an initial petition filing in order to try to avoid a request for evidence. And also, getting policies into place as far as notifying a immigration counsel of upcoming travel plans for a foreign national employee, making sure that those travel plans are fully reviewed for risks, not only the normal risks, but also any additional risks that might come about due to any executive orders that are implemented by the new administration.
I think that's a really key point in terms of just having those contingency plans. Have a plan B if you're traveling, and for employment, that might mean talking with your manager about whether or not remote work is going to be possible if you end up abroad longer than you thought you were, or what coverage will be in place if that employee is gone for several more weeks than you thought they would be. And from the employee's perspective, having those work arrangements settled out, but also, who's going to feed the dog while you're gone if you end up longer than you thought you were. So having all those contingency plans in place and expect delays, I think is
right.
Really key.
And I think another important thing is, foreign national employees are going to have a lot of anxiety over the changing administration and over what may happen, all the what ifs that come with that. So having resources for those employees, talking to your immigration attorney or provider about, doing webinars or town halls to go over questions that your employees may have, try to hopefully ease some of those concerns, or having, office hours internally for those foreign national employees to just give them an outlet, for their anxiety or their frustration over their status or the potential impact. Is also important, because there are just so many what ifs with any changing administration.
Yeah, talking to a professional and maybe saving yourself from the rumor mills online. Another good call. Use us as the experts that you have. For immigration lawyers, the holiday season includes an extra holiday. We get Thanksgiving, Christmas, New Year's, and then the H-1B cap. For H-1B cap that we're starting to think about coming into the new year for folks being registered, just sort of open to the panel here. Are there any legal changes we expect coming down the pipe? And is there anything special we think employers should be doing different in a Trump administration in terms of getting ready for the H-1B cap? And maybe for those who don't know what the H-1B lottery is, let me just give a quick PSA on that. The H-1B visa is a very common working visa. They only give away 85,000 of these things every year. Every year they're oversubscribed. And in March, they run an online lottery that will pick who gets to apply for an H-1B visa. So with that, Anne, apologies.
Yeah, sure. So H-1B registration and selection in the last few years takes place between like March 1st and March 20th, is my memory serving me right? So I can't imagine that they can get anything done to impact registration and selection for this coming year. In the previous administration, there was talk of, a merit-based system for who's selected in the H-1B cap, but I don't see that they could get that done for this year. Yeah. That said, they could get something through regarding petition adjudication for the H-1B cap and policy memos and regulations regarding who qualifies for H-1B, as we've discussed before. So that could become more difficult and impact the H-1B cap.
So that more strict environment, just having a spread-on effect to the H-1B cap as well. Something in mind I'm talking to clients about as well is think about who you're including in your cap registration this year. And if you have somebody, for instance, working on an H-4 EAD that you weren't worried about before, maybe now is a good time to put them into the lottery to see if you can get them an independent H-1B, just in case that EAD or some other form of work authorization they may have, like TPS, goes away. Okay, so that's regulations. A lot of possibility there. Definitely another item we'll be watching very closely and talking with clients about as things develop. We've saved a little bit of time here for the end to talk about potential congressional action. there's a certain architecture here that we all assume is in place, that we have H-1B visas, that we have a green card path through employment. What are some potential changes we can at least start thinking about in terms of a Republican-controlled Congress and a more restrictionist view on immigration?
In my opinion, this one is the biggest wild card as to what could get through, because again, has to pass the House, has to pass the Senate, get past filibuster, and signed by the president. So I think legislation by Congress is the biggest wild card ahead of us. In Trump 1.0, there was discussion about introducing through legislation merit-based or point systems as to who is selected for H-1B or who otherwise receives visas or green cards. So that is points for education, career level, wealth, connections to the United States, English fluency, job offer. So I think it's likely that we'll see a bill propose a merit-based or a point-based system. And then it's just going to be interesting how limited or far-reaching that will be based on the makeup of Trump's advisors. So we've got Stephen Miller, chief of staff, anti-immigration more broadly. We also have Elon Musk, who is an immigrant himself in the technology AI industries. And he has said, we need to welcome immigrants who are productive, honest, and net contributors to the United States. So it's going to be very interesting to see the interplay between differing opinions in the Republican Party, and then how aggressive they are going to attempt to be regarding bills that are proposed in Congress. So this one's stay tuned.
All right. So I think that brings us about to the close of the presentation for today. I know we've covered a lot. Some reassurance that, we've all been through this before. We were able to navigate a Trump 1 administration, even with some of the headwinds and delays and difficulties getting cases approved. This is where
amplified by COVID in the last year as well.
That's right. I forgot about that. So, important to have a skilled team on your side that can help you navigate some of these issues. And we want to leave you today with just sort of some positive, constructive things for those who might be concerned and nervous about the road ahead. We'll publish this as well in the LinkedIn page for folks to refer back to, but just sort of a greatest hits one-pager of things we can be doing right now to get ready for the new administration that's coming in. Premium processing, use it if you can afford it, but plan to have it restricted in the future. This was paused. So, what is your plan for new hires if there's no premium processing? Be talking about that with your attorneys. We talked about the fact that government wage requirements may be going up, maybe really significantly, and that can make it ever more important to obtain or maintain your existing access with your comp folks to have a private wage survey available. That is written into statute thus far as your right to, as an employer, to use if the government data does not seem realistic for that case. Starting your green card cases 3 to 4 years out. I used to say 2 years. Now I'm saying 3 to 4, maybe 4 or better under a Trump administration where things might continue to take longer on that front. Supporting backup options wherever you got them, right? If you've got somebody with a pending green card case and has a work permit, if you're deciding whether or not to keep that H-1B or that L-1B visa going, I'd say the recommendation for now would be go for it if you can work that into your budget. In terms of your communications with your employees, look at your communications with your immigration practitioners now. What are you saying about travel concerns and document checklists, and how might we want to update those for an expectation of maybe tougher consular appointments and maybe longer wait times for visas. Communications among HR groups and among managers of your sponsored employees, that increased details are worth the effort up front to try and avoid the kind of back end delays you can get. If you can avoid that request for evidence, you should try. And then sort of what we closed on there on the H-1B cap lottery, look maybe with a more expansive view of who you might register in terms of that H-1B being ever more important as a backup option moving forward. So we're happy to take questions offline and hope this was informative for all of you. Thank you for taking time out of your busy schedules. This will be only the beginning, really, of the planning that will come to get us through the next 4 years. So appreciate your time. And thank you to the panelists.
Thank you.
Thank you.
Thanks, everyone.